All right, if we get everybody back, please.
And Your Honor, if the court reporter could just tell me where she last heard.
Yeah, let's go back on the record. And Ms. Hyman, what was the last thing you were able to report?
The last question was, okay, and with your training and licensing work experience, do you believe Tracy maintains a healthy, sober lifestyle? And the witness said, as far as I know, and of course I'm not there 24/7, but I have, and that's where I lost it.
Okay, Ms. Savage, can you pick up from there?
Miss Ashton, can you repeat your answer? So you have seen it, and I guess what is she doing to maintain that lifestyle?
Yeah, I was just saying that I have seen Tracy reach out to her support system, both to myself, to other professionals, as well as her peers in recovery. I know that she goes to meetings. I know that she is working. I know that she is maintaining contact with, like I said, reaching out when she's having a difficult time. And so, those are the types of things that we coach our clients to do in their recovery. And, she's been able to maintain her housing. She's been able to work and start to do all of the things that we ask her to, and through some really difficult things. And so, she's doing all the things that would indicate to me that she's maintaining her recovery.
And I think my last question was how long her sober support systems will be available to her. So yourself and then Miss Potts, her recovery coach.
Right. And that was, the answer to that is indefinitely. We are not going to cut ties with her. That's not a kind of thing that we do in our community. Her coach is able to provide coaching services to her until they determine together that there's not a need any longer. But we also have an alumni association among our clients who've completed services with us that allows them to stay in contact with the agency indefinitely. And so they participate with one another in activities. They stay in touch with us as an agency. They do things that help them give back to current clients and participate inside our facilities and our services. And so there are a lot of ways that she'll be able to maintain contact. And of course, she has my contact information as well as Melissa's, and she knows that she can reach out to us at any time.
And actually, to your knowledge, she does reach out to yourself and Miss Potts, correct?
Yeah, absolutely. Because we speak to each other. We're in the same office and we speak to each other daily.
I'll pass the witness around.
Ms. Price.
I have no questions for this witness.
Ms. Pearsall.
No questions.
Ms. Swallow.
No questions.
Ms. Harris.
No questions, Judge.
May this witness be excused.
Yes, Your Honor.
Thank you, Ms. Ashton, for your time and your testimony today. You're free to go about your day, and I'll remove you from the hearing now.
All right, thank you.
Ms. Savage, any other witnesses?
No, Your Honor, I rest.
All right. Ms. Pearsall, your case, anything?
Your Honor, I'll call Mr. Martin.
All right, Mr. Martin, can you please unmute?
Yes, sir.
As you've heard me say several times today, Ms. Pearsall is going to ask you some questions. The other attorneys are going to have the opportunity to cross-examine you. If you hear somebody object, please let me address the objection before you keep talking. And please speak loudly and clearly, as Ms. Hyman is reporting all of this. And I'll remind you that you're under oath. Ms. Pearsall, you may proceed.
Mr. Martin, state your name.
Corey Martin.
And what are you asking the court to do today?
What am I? I'm sorry, repeat it.
What are you asking the court to do today? Where would you like your children to go?
To go to Tracy Bishop.
Okay.
Her mother.
Okay. And are you willing to follow any rules the court gives you if the children are returned to their mother?
Yes.
Okay. You willing to make sure that you don't violate any visitation rules?
Oh, yes. Yes, ma'am.
And you're willing to support the children if the court orders it?
Yes, ma'am.
And do you think it would be in your children's best interest to be with their mom instead of with strangers?
Most definitely.
Can you tell us why?
Because her as a mom is just, that kind of love is, nobody else can speak to that. She loves her kids with all her heart. Pretty sure of it.
And from what you've seen about your children, do the children love their mom?
Last I've, heard or seen, yes.
I'll pass the witness, Your Honor.
Ms. Price?
Mr. Martin, if the court orders that you cannot go around Ms. Bushman and the children, are you willing to abide by that?
Oh, most definitely.
And do you realize and understand that if you were to violate such an order, that you could risk Ms. Bushman being able to care for the children?
Yeah, I definitely don't want that for her.
Okay. And are you currently working?
Yes, ma'am.
And you would be able to abide by any child support orders the court might put in place?
Yes, ma'am.
Okay, I'll pass the witness, Your Honor.
Ms. Savage?
No questions, Ron.
Ms. Swallow?
Mr. Martin, have you seen Tracy with the twins since January 2023?
No, ma'am, I have not.
Have you seen Tracy since January 2023?
Just here in court.
Are you still using methamphetamines?
No, ma'am. I'm trying to stay sober, but it's a lot more difficult here in San Antonio.
I'm sorry, a lot more difficult. What?
Here in San Antonio, where I'm at.
Thank you. I pass the witness.
Ms. Harris?
Have you sent any support, financial or diapers or anything? Have you sent anything for the kids?
I've sent, I think I, gave Tracy some money without her asking or anything, just when I had some extra money to give.
When was that?
Oh, I can't even remember.
How much have you sent her for support?
Oh, just a couple hundred.
And did you send anything for Christmas for the kids?
No, ma'am, I did not.
Anything for their birthday?
No, ma'am, I have not.
Why did you decide not to work the services that the department was offering to you?
Well, it's kind of a difficult story, but I did not believe that I was the father for a long time until I found out, through the DNA test that I was. And then after that, I have not talked to Tracy, so I haven't been keeping up with that part of my life. I've just been working and
When's the last time that you... It's okay. When is the last time you spoke to Miss Bushman?
Back in January or whatever, that I've spoken to her.
Since January of what year?
23, I think.
Are you aware she said she spoke to you in December 23?
Maybe I have the time wrong. I'm not sure.
Has she ever let you know that she considers you a trigger for her relapsing?
Well, I'm sure I'm very much a trigger. That's why I've been trying to stay.
Are you under the influence of any substances today?
No, ma'am.
Do you have any other children?
Yes, ma'am.
Where are they, sir?
One is an adult, and she's living with his sister, and my son James has been adopted.
Was that because of a CPS case?
Yes, ma'am.
Where are you living at this time?
In San Antonio.
Is it the same residence where the children were removed from?
No, ma'am.
You
I
don't
have
need to
my
give
own
me an
apartment.
address. Just tell me approximately where you're living.
I have an apartment on the northwest side of San Antonio.
Does anybody live there with you?
Yes, ma'am. I have a roommate.
And do you know if that roommate has any criminal or CPS history?
No, ma'am. He does not.
Does that roommate use drugs?
No, ma'am. He's
Would your
an older gentleman that I've known for quite a while.
Would your home be an appropriate place for Jasmine and Jameson to live?
I would need to do some safety updates, but other than that, yes, ma'am.
I'm sorry, say that again.
I said other than like some safety updates and stuff we need to address, like the wall outlets and cabinets and
Do
whatever.
you have beds for the children?
I do not.
Do you have a bedroom for them?
I'm in a 2-bedroom apartment, and it's me and my roommate, so they would not have their own room per se.
Do you have any photos of your children?
I have photos of my son. I've seen pictures through friends, mutual friends of me and Tracy's that she's kept in touch with. I mean, I see them through that way, but I haven't seen them in person in quite a while.
Has Miss Bushman ever sent you any pictures?
No. Just of my son, and that was back in, I haven't even seen him in a year, I guess.
I'll pass the witness, Your Honor.
Redirect.
No, Your Honor.
Just briefly, Judge.
Oh, go ahead, Ms. Swallow. I'm sorry.
Thank you. Mr. Martin, is Tracy the mother of James?
Yes.
And both your and her rights were terminated in a CPS case?
Yeah, they were both relinquished. Yeah.
And that was for use of methamphetamines?
Yes.
How much do you make a month financially?
Make about, I can't even add it up right now. I'm like like 2,800 a month, 3,000.
Do you pay child support on any other children?
No, ma'am, not anymore. Like I said, my daughter is grown up and away from the.
Thank you.
Mom.
Thank you, Mr. Martin. I pass the witness.
Any other questions for Mr. Martin?
Yes, Your Honor.
Go ahead, Ms. Swallow.
The 2,800 you make a month, is that before taxes?
No, ma'am.
Hmm?
No, ma'am.
Okay. They take taxes out and then you get 2,800 a month?
Yes, ma'am.
Okay. Thank you. No other questions.
Any other witnesses? Ms. Pearsall?
No, Your Honor, I rest.
Okay. Ms. Harris, witnesses?
Yes, I would like to call the CASA advocate, Your Honor.
Is that Ms. Potts?
No, that would be Jill.
Oh, I'm sorry, Ms. Roden. Okay, I just didn't know if we had a volunteer on this case. Okay, Ms. Roden, I know you've heard everything. You've testified before me before. You know the rules, and just remember you're under oath. Go ahead, Ms. Harris.
Ms. Roden, how are you associated with this case?
I am the CASA program director, and I've been working the case since January of 2023.
And during that time, about how many times have you seen the children?
More than 10. We see them monthly, so.
And have you been able to observe them with the foster parents?
Yes, ma'am.
Have you been able to observe them with Ms. Bushman?
Yes, ma'am.
Have you been able to talk with the Fords about how the kids are doing?
Yes, ma'am.
Have you been able to talk to Ms. Bushman about how the kids are doing?
Yes, ma'am.
And what is your understanding of why the children were initially removed?
Due to methamphetamine use.
And would that also be considered neglect?
Yes, ma'am.
And do you feel like Ms. Bushman has addressed her drug use during this case?
I feel like she's addressed the drug use, yes.
Do you feel like she has addressed the neglect of the children adequately in this case?
I don't. I guess that's where our concern still lies, just with her ability to safely parent the children.
And what are those specific concerns? And if there's a whole lot of them, I can go one by one so that you don't have to ramble.
I'll try to be succinct. If at some point you would rather ask questions, go ahead. I think that the concern has been kind of ongoing, especially post what we believe is Ms. Bushman's sobriety, is just not a real change in the parenting of the kids. You know, we have the family-based safety services case where, you know, she continues to use, she's using in the house with them. And then during the reunification, even though she was no longer sober, just kind of the same maybe approach to parenting. She wasn't necessarily making sure that all of their needs were met. She was vaping in the house with the children. So I guess it would be the pattern of maybe not always putting the children's needs first that has been a continued concern for CASA.
And have you been able to observe some of the visits with the children?
Yes, ma'am. Probably
and how do you feel like those went?
Overall, the ones I have been to have gone fairly well, but just the same pattern kind of concern continues into those visits. So whether it be sometimes, you know, needing further assistance to meet both kids' needs, or you know, there was a visit where there was a fall and accidents happened, but just kind of maybe her ability to pre-plan or really make sure both kids are getting the attention that they require to remain safe.
And are you taking into consideration that these are twins? They run around, it's tough for one parent?
I am, yes. I do know that it's tough.
Are your concerns because she's a single parent, or is it because of her parenting style?
No, it's because of her parenting style, not because she's a single parent.
And has she seemed open to any suggestions or critique that she's been offered?
I think that she is somewhat open, but she tends to kind of minimize. I've kind of seen her roll her eyes about their thickener in a visit. So I think that she is somewhat open, but I think that some of the changes have been lacking, or some of her acceptance of the issues have been minimized.
So do you feel like the children will be in any kind of danger if they spent any immediate danger, if they spent a few hours with their mother?
I would be concerned of the risk that's there, just with her sometimes inability to meet, like I said, both of their needs and kind of put them and their needs first.
And what about her long-term ability to meet their needs? What is your impression of that?
I would be concerned. I mean, I have, you know, just looking at past history, I know that people can change. I know that Ms. Bushman, I don't want to minimize her changes and the work that she's done, but sobriety doesn't always equal like a safe and stable home. And I think it's that safety piece and parenting changes that are lacking. So I'd be worried in the future just based on what we know now of her parenting abilities.
And are you aware there may be some differences in income level between Ms. Bushman and the Fords?
Absolutely.
Are you making any of your recommendations based upon that?
Absolutely not.
Is it fair to say that you've spoken with the Fords probably more often than you've spoken with Ms. Bushman?
Probably, just because of the requirement to see the children monthly and the amount of time the kids have been with the Fords.
And would your recommendation be based upon whether you like the Fords or Ms. Bushman better?
No, ma'am.
And what is your recommendation? Do you believe that the children should be placed with, and I'll do this in a couple phases. Do you believe they should be placed immediately with Ms. Bushman to reside there permanently?
No, ma'am.
Do you believe that they should be placed there in a transitional kind of monitored return?
No, ma'am.
Where do you think they should be placed permanently?
I think they should remain in the care of Mr. and Mrs. Ford.
And do you think that's in their best interest?
I do.
And why do you think that's in their best interest?
I believe that's in their best interest because the information that we have on Ms. Bushman's ability to parent the kids safely and to not put two 18-month-olds in danger. And then what we know about the Ford's ability to parent the children, I just believe they'd be safe and stable and have all of their social and health needs met with the Fords. And I can't say the same for Ms. Bushman right now with the information that we have.
And is it your understanding that the department or Ms. Bushman are asking that the kids be placed back in a step up kind of a monitored return?
That's my understanding.
Why do you not think that would be successful?
I just have fears that we're trying something that put the kids back in danger. We all tried it in October. The kids were back in danger. I worry about the oversight during the reunification. There were some concerns with the oversight during the previous reunification, how often the children were visited. So I feel like placing them with Miss Bushman is very risky and puts the kids at risk, being as young as they are and having the medical needs that they have and just the needs developmentally because of their ages. I think it's a great risk to the children that we would be taking to do that.
And how old is this case?
It's been open since January of 2023, so a year and a half, roughly.
And do you think that the children deserve some kind of permanency anytime soon?
Yes.
I'll pass the witness, Judge.
Ms. Price.
Thank you, Your Honor. Ms. Roden, are you asking the court to terminate parental rights today? Or I guess, are you recommending? Because I guess CASA doesn't ask necessarily, but is that your recommendation, is for termination of parental rights?
With my understanding of the options that are on the table right now, yes.
And what are the specific actions or inactions from Ms. Bushman that you can point to that lead to that recommendation?
I think that would lead to the recommendation would be, she has worked her services, and like I said previously, I don't want to minimize that, but I worry about her ability to meet the goals. Like when we all met and we had the family group conference, we developed goals in addition to those services. And so my concern says that her ability to safely parent the children hasn't really been met as part of that. I also, we've had some conversations where, she's just said things kind of like, I think it was the nebulizer that was making the wet sounds. And so I stopped the breathing treatments and just kind of things like that, where I feel like the kids maybe needs wouldn't be met.
And which specific goals that were developed during the family group conference do you think that she has not demonstrated that goal has been met?
I think the ability to safely, to provide a safe and stable placement for the children.
What would she have needed to show for you to have come to a recommendation of a monitored return?
Sure. I think in that initial monitored return, I would have been hopeful that she would have been able to maintain that stable housing. I think the plan was for her to remain at Sarah's house until she could get on her own. So for me to make that recommendation, I would have liked to see her be successful in maintaining that stable placement for the kids and then safely moving into the apartment instead of the situation where the kids had to be moved. They had to spend the night in the shelter. So her able to kind of maintain that, her ability to not vape with the children after taking classes that, talked about why she shouldn't. My understanding was that Ms. Powell provided that education and information, and yet Ms. Bushman continued to do that with the children, even knowing how everybody in the courts felt. So I think to see her have made the appropriate changes and made sure that initial reunification was safe and stable for the children would have absolutely changed my recommendation in this case.
So is it safe to say that once that initial monitored return was unsuccessful, that at that point there was nothing she could do to change your mind to the contrary?
No, I don't think that would be a fair statement. I think that there was still, when I earlier referenced kind of her rolling her eyes out of the thickener, that was after the removal from the home. The conversation about the nebulizer, I believe, was after the kids were removed from that. So some of those behaviors seem to kind of continue. I think that had, she picked up from that removal of that monitored return and really been able to articulate, and I don't mean articulate well, but I mean, all of us had felt like she understood why they were removed, understood the danger that they were placed in, had a plan for how to make that different. I think that also would have changed my mind at that point as well.
So is it a fair assessment that, I don't want to say that she did too little too late, because you did acknowledge that she did complete her service plan, but maybe the emphasis is on the too late part of that statement? Is that fair to say that that's kind of how you're feeling here?
I think that considering kind of the legal timelines, I think that plays into it some, yes.
Okay. I'll pass the witness. Thank you, Ms. Roden.
Ms. Savage.
Ms. Roden, you testified that her being able to maintain housing is an important factor for you, but she's maintained her apartment for the last 6 months. Is that correct?
Yes, ma'am.
And have you been able to make a visit out to that apartment to see if it's appropriate for the children?
No, I visited by Zoom with Ms. Bushman back several months ago, I think in April.
Okay. And then you'll acknowledge that Ms. Bushman has made significant changes from January to today.
January of 2023 to today?
Yes.
Yes.
Okay. And you'll acknowledge that when the kids were in her care, she was taking them to medical professionals, correct?
Yes.
And actually, that was the only time that Jameson's swallow study indicated he was not aspirating, correct?
Yes, but I do believe at the bottom of that swallow study that it was at a risk for aspiration. He was at a high risk or at a risk for continued aspirations.
Okay. And you'll acknowledge that the nebulizer is as needed treatment, correct?
Correct.
Okay. And you'll acknowledge that her, stopping the thickener was under the advice of the primary care provider for the kids, correct?
I think my concern with that is that I've seen the doctor's notes, so yeah.
Objection, Your Honor, non-responsive.
Yes.
Same.
It was at the advice of the doctor, correct?
I've seen a doctor's note, yes, after.
And if judge does grant the monitored return, obviously CASA still stays in this case. The ad litem still stays in this case. Is that correct?
Absolutely.
Okay. And the children would continue to be enrolled in daycare, or different daycare, but daycare with Miss Bushman, correct?
That's my understanding of her plans, yes.
Okay. And there's going to be a courtesy worker who's also in the area who's able to see the children, correct?
Yes, ma'am.
Okay. And so while, you know, your hesitancy is understood, we would be able to continue to monitor these kids and make sure Ms. Bushman has addressed the issues that you're acknowledging were from back in December and January.
I would hope that there would be oversight that would allow us to monitor that, yes.
Okay. I'll pass the witness, Your Honor.
Ms. Pearsall.
What is the point of child protective service cases as far as you understand?
Ensure safety of children.
Do you understand that if a parent does these services, it is the job of the court and the intent of the legislature to unify parents with their children?
That's always our first goal, yes, ma'am.
No other questions.
Well,
Thank you, Judge. Ms. Roden, you testified that you've been able to observe the children with the foster family and you've been able to observe the children with the mother, correct?
Yes, ma'am.
We've heard a lot of testimony regarding how these kids are bonded to their mother, correct?
Yes, ma'am.
Do you have, can you share with the court any observations you have made in regards to the children and the foster family?
Sure. I mean, I've made a lot of observations there. The children seem comfortable. They seem familiar to the home. They seem very bonded to Mr. and Miss Ford when I visited in the home. You know, if they drop a toy or drop food, they look to the parents, kind of showing they rely on them, those sorts of things.
Okay. And do they seek out comfort and affection from the Fords?
Yes, ma'am.
Okay. Do you believe that the back and forth of a monitored return is in the best interest of these children?
Not at this time, no.
And can you elaborate a little bit? You said something about breathing treatments and mom telling you she thought it made the kids worse or something to that effect. Could you elaborate more on those circumstances?
Yeah, we were just having a conversation about the kids and their needs, and she had stated that when the kids are with her, that she felt like when they had the breathing treatments, they sounded worse, and she felt like it was the breathing treatments making them worse, so she stopped them.
So she stopped them.
Mm-hmm.
Was that a yes?
Yes, ma'am. Sorry.
Do you have concerns regarding the recent positive nail test?
I do definitely. The 4 to 6 months that we heard earlier could be the window, could have included when the kids were with Miss Bushman, I think is my greatest. That I heard today that it was environmental, and that definitely could have covered the time that the children were in the reunification. Definitely has me concerned.
Were the children ever tested after the after the failed monitored return?
Not to my knowledge, no.
Okay. Were you recently able to observe a visit between Miss Bushman and the twins?
It's been about a month ago. Yes, ma'am.
Okay. Was it since our last court hearing?
I can't remember. There's been 3. I don't think so. I think it was between the first 2.
Okay. And did you have any, how did that visit go?
Overall, it went fairly well. Miss Bushman brought the double stroller. She sat with the kids. The part that I was at, I got there a little bit after them, so they had already eaten, but she brought them appropriate food from McDonald's. The only concern was when they were both climbing on the play place, and I think that she was just a little unprepared for them going 2 separate directions. And so Jasmine fell, hitting her face on the rungs of a ladder. And Jameson, I kind of got up and helped Jameson down the slide.
You kind of got up and helped him, or you had to get up and help him?
I had to get up and help him. I mean, he's kind of a toddler, and he was toddling towards a slide that was higher than my head, and she was trying to address Jasmine slipping down the ladder. So I had to get up and make sure he didn't fall down the slide.
Okay. Have you had any contact with Mr. Martin?
No.
Have you ever tried to meet him at all?
I've tried to call him multiple times in the beginning of the case at the phone numbers that were available to us. And I've also talked to the caseworker about, do you have an address? Do you know where he lives? And I think at that time she was meeting him away from the home. And so she didn't have an address that was good to my knowledge.
Okay, thank you. I pass the witness.
Harris, any redirect?
No, Your Honor.
Any other questions from Ms. Roden?
Yes, Your Honor.
Go ahead, Ms. Pearsall.
Ms. Roden, Mr. Martin has participated in some of the prior hearings as well as mediations, correct?
Yes, ma'am.
Okay, so you have had some interactions with him, just maybe not outside.
Yes, right, just not outside of court. Yes, ma'am.
Okay, now the questions.
Any other questions for Ms. Roden?
No, Your Honor.
No,
All right.
Judge.
Thank you for your testimony, Ms. Roden. Ms. Potts is still in the waiting room. Is anybody going to call her?
No, Your Honor.
Okay, I'm going to bring her in and excuse her. Ms. Potts, if you're there, can you please unmute and turn on your video?
Yes, sir.
I just wanted to let you know that the parties have called the witnesses they're going to call, and
Okay.
you are not going to be testifying further. And I wanted to thank you for your time and your patience today, and let you know you are excused and free to go about your day.
Yes, sir. Thank
Thank
you.
you. All right. Anybody have anything else that they need the court to consider before we go into closing?
No, Your Honor.
Okay. I understand, based on the procedural posture of this case, that the department, as petitioner, is seeking the monitored return, and the interveners are seeking the termination. So despite that, I'm still going to go in the same order of petitioner and then other parties, and give the petitioner the right to rebuttal. No other party will have the right to rebuttal. So does anybody need any time before you present your closing arguments? No? Okay, Ms. Price, you may proceed.
Thank you, Your Honor. This case reminds me of a saying, a couple of sayings, but the first one is, "There but for the grace of God go I." And I think to the fact that we are all but one phone call away from the scrutiny that the department can put in any of our lives. The evidence was absolutely clear and uncontroverted that Ms. Bushman had a long and serious addiction to methamphetamine, one that she may be addressing for the rest of her life. That addiction has cost her the parental rights to other children, and it has cost her the care, custody, and control of Jasmine and Jameson in this case. It may have also led, or at least contributed to, a number of the issues that they have currently. The reason that I'm reminded of the saying, "There but for the grace of God go I," is because I was also a single mother of twins, and I was very young, and I did not know how to bathe them, and I did not know how to feed them, and I did not know how to do any number of the things that we expect parents to know how to do. Which leads me to another saying that I'm reminded of, and that is, it takes a village to raise a child. Because I did not have a long history of addiction, and because I did not have the scrutiny of the department in my life, I had the luxury and the privilege to make mistakes as a parent. I had the luxury and the privilege to forget to go prepared for an outing with my twins. And that wasn't putting my parental rights on the line. I was able to have somebody show me how to bathe them, how to feed them, how to do all of the things that we expect parents to do. I was able to have somebody help me determine who their pediatrician was going to be and how I was going to get there and how I was going to balance school and working and them being in daycare and all of those things. And it wasn't held against me that I needed that help. Because of Ms. Bushman's history of addiction, we are now pathologizing all of her within the normal range of parenting style to be a life and death situation for the twins. And I think that we are unfairly elevating the issues and the concerns with her parenting abilities. And I think that is in large part because, yes, those were choices that she made. That was the life that she lived that led her to this point. But the purpose of a CPS case is because once that has happened and once the scrutiny of the department is in a family's life, the purpose and the intention is to make it safe for the children to be reunified with their parent or parents. The main reason that we are involved is because of Ms. Bushman's long history of methamphetamine use. And the evidence before this court is that she is doing all of the things that we would expect somebody to do who is committed to their sobriety and to sober living. She did not she did not react to the children's medical needs in the way that we would have liked her to. She does not think through all of the needs that they would have for visitations and things in the way that we would like her to. But I think that what is most important, Your Honor, is that she did get there in the end. And at this point, to move towards termination at this point, at this juncture, to me, it feels like what is the purpose of this process? If we're going to get to this juncture and the reasons for termination are, yes, I'm not discounting the long history of addiction. I'm not discounting that. But we knew that going into this process, and we knew that going into the reunification efforts. And so to do so at this juncture feels like we're doing it because we wish it would just be a little better. And I feel like that's not the test. That's not what we're supposed to be weighing. I think at this point, what the department is asking for and what Belong is asking for is the reasonable transition back to her care in a way that still ensures child safety and ensures that they have all of the treatment and needs, all of their medical needs, that we can transition them in a way that's safe so that their new providers are in place before they get there. And so the 4 to 6 weeks that the department is asking for, where she has, starting with 4 hours of unsupervised one weekend and then another 4 hours the next weekend, the things that we're asking for, that is a reasonable transition plan that allows Ms. Bushman to show to this court that she can, in fact, take care of these children. And whether she utilizes her village to do so, I think shouldn't be held against her. It's one of the things that we ask parents to do, is to create these safety and support networks for them. And we've heard from witnesses to say that Ms. Bushman has done precisely that. And so the department and Belong is urging the court to grant them the transitional monitored return. We're asking for the dates that are in the in our motion to simply be updated to reflect where we are now, with a 4-hour visit. If it's too soon to take place this weekend, then the following weekend, a 4-hour visit, followed by another 6-hour visit, followed by an overnight visit, followed by another weekend visit, until placement can take place. And if the court feels that even a longer transition, we believe 4 to 6 weeks would be a sufficient time to see and make sure that Ms. Bushman is able to do so in a way that addresses the children's needs, and should address the concerns of those who worry about those parenting choices or that parenting style. And so we ask that the court consider that and make that ruling at this time. And thank you, Your Honor.
Thank you, Ms. Price. Ms. Savage.
Your Honor, we are completely in support of the transitional monitored return and do believe that that would be in the best interest of the children. Based on the evidence, what we know is that Ms. Bushman has completed all her services. We know that she is sober and she continues to use her sober support system to maintain that lifestyle. We know that she has appropriate housing. She's maintained that housing for the last 6 to 7 months. We know that she's employed and she continues to be employed. We know that she is bonded to the children, and more importantly, that the children are bonded to her. These kids know who their mother is. And to sever, and that's what they're asking for, right? The termination cases are the civil equivalent of death cases. Terminating Ms. Bushman's rights when she's put in so much work to change her lifestyle and to make the requested changes that we put on her. And she's done. And she's maintained that for months, right? This isn't, she just moved in last week to her apartment or last month. She's been in this apartment since roughly the end of January. She is done everything for these kids to show that she has changed. What we know is that when she had the children in her care back in October to December, while she might have minimized, according to everyone, some of the medical conditions of the kids, she's still taking them to the doctors regularly. She had still scheduled them for a swallow study, which actually that was the only time that Jameson's had a swallow study that indicated he wasn't aspirating. So maybe the doctor telling her we wean him off the thickener or we take him off the thickener might have been in the right move, because according to their own expert testimony or their own testimony from their speech therapist, that is the treatment goal for children who need thickeners. You wean them off little by little, they need less. So to say that Ms. Bushman does not take their medical conditions seriously, I think isn't a fair assessment, because she was doing all the things we were still asking her of. She had enrolled one in speech therapy and was getting the other one started in speech therapy as well. So I think the evidence that we have today does not meet the burden of clear and convincing for termination as to a ground and as to best interest. Because all the people who have seen Ms. Bushman in the home with the children have all said that she's attentive, that the children are bonded to her, that they had no concerns for her ability to care for the kids. The ones that we have saying, oh, well, she could have done something better, are seeing Ms. Bushman trying to wrangle 2 toddlers in a public setting, in a gas station, McDonald's, in a barbecue joint. I mean, I think any parent of small children, especially toddlers, can recognize and understand when you're in a public setting, it gets a little difficult. You add 2 that are mobile, it gets pretty difficult. But to make that assessment that, oh, she could be a better parent, she should be able to catch her toddler from falling and him not fall and hit his face when he's learning to walk, when he's climbing, when he's running, that's not a fair assessment. What I do know, though, is that when Ms. Bushman had the choice to put the kids in a shelter versus letting them go to a placement where she knew that they could receive the care while she was getting back on her feet. She made the choice selflessly to put her kids first. She made the choice that she wanted to make sure her kids' needs would be met and sacrificed what would be in her best interest and what would guarantee her getting her kids quicker, because she cares so enormously for her children. So when the court is considering whether that tie should be cut today, I just hope that that is a piece of information that is kept in your mind.
So it's Ms. Pearsall.
Judge, this case is the whole reason as to why law exists and is drafted and why this court exists. And all of us, or most of us, I should say, do this for a living. Any case, regardless of the facts, if you look at a biological parent and then you look at a foster family, by definition, foster families are richer, are more educated, and don't have any known drug or criminal history. Sometimes they do that we don't know. And as much as Ms. Swallow elicited from every witness, oh, this isn't about the money. This is exactly about money. Yes, they are richer. Yes, they can afford an attorney. Yes, they can afford to subpoena witnesses and pay for their testimony. But that's not the purpose of why these cases exist. Every parent comes into CPS court because they have an issue. They're a victim of domestic violence. They are drug addicted. They're having some mental health issues. They have something they're struggling with. And what this court tells them at the very first hearing, and what the department tells them at every staffing, at every family group conference, is if you get it together, if you do the classes you've been court ordered to do, the goal is to reunify you with your children. And Ms. Bushman did that. And to consider anything, giving Mr. and Mrs. Ford any rights, honestly defeats the purpose of the system. She doesn't just deserve to have her children back. Anything else, in my opinion, would be unconstitutional and go against not just these children's best interests, but everything that the system is set up to do. And I think what most clearly demonstrated that is when she was asked, would you like Mr. Martin to have some visitation? And she said, no, not until he finishes drug treatment. I mean, that's huge. She truly gets what the issues are that brought her here, and she has demonstrated being clean and jumping through all sorts of hoops under a microscope for many, many months now. So I'm asking that you order the monitor to return. I very strongly suspect, based on this never-ending trial, that she'll be sabotaged every step of the way by these placement, by KASA, maybe by some other parents. So I think it will be very difficult monitors return. And honestly, Judge, I think the only way to avoid that is to just place the kids there and cut out the people who are going to clearly sabotage it. But I understand that why the court would want to do it in steps and why the department wants to do it in steps. And to assure that Mr. Martin is ordered to pay some support, child support, to help her take care of these children. And I'm asking that that be ordered based on minimum wage.
Thank you, Ms. Pearsall. Ms. Swallow.
Thank you, Judge. I want to start by saying that while I appreciate Ms. Price comparing this case to her life, it's a completely different situation. Ms. Price was not a meth addict, and nor did she have the department involved in her life for 19 years prior to having her twins. So they're not comparable in that sense at all. We've already tried returning these children to this mother twice. They were able to come home to the hospital with her after she and the children both had tested positive. That did not work out. She continued to use. They were then placed back with her in October of 2023 in a monitored return, which then failed. The system is not set up to continue to place children back in the care of their parents when their parents continually are unable to properly care for their children. I don't believe it was a choice of Miss Bushman to allow her children to go to a shelter. The department removed the children. If it was a choice, then Miss Bushman would have gone with the children to a shelter. There was a situation for which it was no longer safe for the children to be with Miss Bushman. I would request that the court take judicial notice of the entire file. It is my client's position that it's in the best interest of the children that the parental rights of Tracy Bushman and Corey Martin be terminated. Ample evidence by the way of testimony and exhibits have been provided to the court. And I believe that all of the evidence has met the burden required of clear and convincing evidence standard for termination of the parental rights and Corey Martin. As to Miss Bushman, as already stated, and as the court knows, she has a very long, clear history and a pattern of abuse of methamphetamines by admission and several attempts at rehabilitation. This includes several prior CPS cases, one of which resulted in the termination of 2 other children. 19 years since 2005, CPS has been involved in her life. It took 11 years for the department to finally terminate the rights between her and her son, John Anthony Bushman. And that case ultimately was due to meth use. She also has another child that was terminated, the baby James Martin, for which Mr. Corey Martin was the father. Same circumstances, meth use and unsanitary conditions. So this isn't just, this case, let's give a mom a chance. There is a clear history of the same facts, cookie cutter facts that match this case, by which it's clear that these children should not be returned to this mother. According to mom's testimony, she's only been using meth for the past 10 years. That's extremely concerning considering that the department's been involved in her life for the past 19 years. I'm not sure what happens in the home of this mother, but if there's not meth use, then it's definitely circumstances that allow for abuse and neglect of children. I believe that the evidence has been presented to terminate mom's parental rights. I believe she knowingly placed the children in conditions or surroundings that endangered the physical and emotional well-being of the children. I believe she engaged in conduct which endangered the physical and emotional well-being of the children she used throughout her pregnancy. They were positive. She failed to support the children. I haven't heard any testimony regarding child support. She didn't pay child support. She was the cause of the children being born addicted to methamphetamines. She used a controlled substance following having completed inpatient treatment. We heard from an expert this morning that stated that Ms. Bushman's nail test went back 4 to 6 months. That means that she had to have been exposed to meth in November, October, or September of 2023. And that is extremely concerning. Even though the expert was able to state that she can conclusively say it was environmental exposure. However, she could not conclusively say that it was not due to ingestion just because the level of amphetamines had not been met, but that does not mean that they were not present. So either way, Ms. Bushman was somewhere she should not have been on a consistent basis after completing rehab just a few months ago, which is, it goes to her credibility and it goes to the safety of these children and what she was exposing them to and what she was exposing herself to. These children should have been tested once they were removed. I believe Mr. Martin's rights should be terminated on the same grounds. Additionally, I believe that he's constructively abandoned these children and that he has failed to comply with his service plan. As far as best interest is concerned, the Fords have provided for these children emotionally, physically, medically, in every way possible since being placed in their home since January 2023. They supported Ms. Bushman in the goal of reunification until it became evident to them that the children would not be safe in her care. there's been multiple opportunities for Ms. Bushman to attend doctor's appointments. The dates were provided. Ms. Bushman never attended. These children deserve stability, predictable stability, without the threat of drug exposure and neglectful conditions. I don't believe compliance is about, checking off boxes on a family plan of service. I don't believe that what Ms. Bushman has been able to accomplish is enough that would allow her children to be returned home. I believe that there was meth exposure. I believe she still, to this day, this morning, she stated she believes that people are, what were her words? Doesn't believe that the children's medical issues are as severe as they are made out to be, that she's never seen them sick. Your Honor, they were hospitalized for RSV. Like, they have been very sick. They have chronic lung disease. For her to have said that this morning was extremely shocking, that after all this time that she would not educate herself and state something different. I don't believe that she has any insight into the damage that she's caused these children due to her smoking every day and using methamphetamines during her pregnancy. Her testimony was that she used several weeks before the children were born premature. There's no way her UA would have been positive for meth if she had used several weeks before. There's no way the children their meconium would be positive if she had only used one time. I have extreme concerns that the mom cannot take care of these children, both of these children, safely. I don't think that, the mindset that they'll regrow healthy tissue, or taking them off a nebulizer treatment, or, taking them off thickener, all these things that she has done, and her failure to recognize that these children have serious medical issues, I don't think that's something that this court can overlook. And I don't think it's something that we should risk placing these children back in her care. I think it could result in very detrimental effects to these children, hopefully not death. Thank you.
Thank you. Ms. Harris.
Your Honor, I would ask you to consider that this case is not just about drug use. There is long-term drug use history, treatment, yes. That is not the only cause for concern in this case. There's also neglect, and there's a long CPS history of neglect too. There's a history of neglect of these children. When they were sent home from the hospital with her, you heard testimony today that she left the children at home without telling anybody, all alone, while she left the home. There were also, you will recall, testimony from one of our previous two hearings that there was neglect in the sober living home. They were concerned about whether she was meeting all of the children's needs. So, Your Honor, with that in mind, I have also tried to base my ultimate position upon the Hawley factors, which I know that you will be considering when you make your decision. To begin with, that's the desires of the children. They've resided with the Fords practically their entire life now. And I know that doesn't give Ms. Bushman much of a chance, but they've been with the Fords because of Ms. Bushman's decisions and choices. So at this point, they now see Tristan and Emily Ford as their parents. I know they're only foster parents. I know that foster parents aren't intended to be forever, but that's why we have time limits on these cases. So kids don't spend 18 months with somebody and begin to think they're their parent. Ms. Bushman at this point is somebody that they got to see for a couple of months, and somebody they see occasionally on visits. They do enjoy her. And I am thinking to the future as well. I think that they are going to want to know their mother. I think that they are going to want her to be a part of their lives. The Fords have consistently maintained that she will allow them to be a part of their life. I understand some of the mistrust in that, but they have been consistently stating to me that they want them to be a part of her life. They were initially extremely supportive of Miss Bushman. They did not go into this looking to take a child away from a parent. The other thing that we have to look at is the needs of the children now in the future. She didn't meet their needs the very short time she had them at the beginning of their life, and she ultimately didn't meet their needs when they were with her for a couple of months. She has a long history with the department, and it can be reasonably concluded from that long history that she can get things together long enough to get her kids back, but then she falls back into the same patterns of drug use and neglect once the supervision is gone. In fact, she's done that in this case. She went to drug treatment, tested clean for a period. The kids were returned to her. However, she couldn't keep everything together more than a couple of months. During that time, the children get the treatment they needed. Hygiene was questionable. She bathed in the presence of the kids, even after education on the dangers of smoking to children. She didn't work despite the kids being in daycare. She failed to obtain housing in a timely manner. And as a result, the kids were removed and she was asked to leave her sober living home. She subsequently had a drug test that clearly established she has not been honest about either her own drug use or her exposure to drug use during a time period that does include the time the children were with her. Ms. Bushman then got housing with the abundant assistance of her caseworker. She's had a couple of jobs that won't be maintainable in that fashion if the kids are with her due to her hours. She's not been to any visits with their doctors or their specialists. She shows no personal knowledge about their needs and admits that there may be nothing wrong with them. You'll recall, Your Honor, that she could not even explain what their diagnoses were, what they were called, to be even able even to pass that information along to a primary provider who she then relied upon, supposedly, to stop giving them the previously prescribed treatments. She's had visits with them that go great. That go okay, not great, but they go okay. I'm not going to nitpick on tiny little details at the visit. However, I will note that something like being repeatedly told to take a double stroller to the visit for twin toddlers shows that she is not able to make these decisions on her own. It does take a village to raise children, but the problem is that Miss Bushman's village up to this point has been CPS. CPS was with her for many, many years before we ever had this case, and CPS has been with her telling her how to do it now. She was in a sober living home telling her how to do it. And yet when she's not prompted, she still is not making those very simple changes to her parenting style. I think there's enough evidence and testimony to conclude that the kids would not face necessarily immediate danger if spending time unsupervised with Miss Bushman. But I think it does show that she's either incapable or unwilling to make the kinds of changes in her life and parenting styles. And that poses a very real long-term danger to Jasmine and Jameson. She's had years and years of guidance and scrutiny without improvement. Years and years of drug treatment with continued relapses and a positive test as recent as this year. I also, considering best interest of the children, would need to look at the parental abilities of the Fords. They have shown not only ability to meet their needs, but a willingness to have them at all sorts of different kinds of appointments, to lose their licensing in order to make sure that these children were going to get consistent, stable, ongoing, loving care. Programs available to assist mom. Right now, her caseworker's assisting her. She has had testimony that she has support through her ongoing drug treatment, but we don't have any people in her life that are not required by law to work with her or have not been involved in drugs somehow that can continue to give her the kind of support that she would need. She hasn't brought anybody to a visit that would show that they can help her wrangle kids. at a visit, it's CPS there doing it for her. So we don't know that she can take advantage of the programs that are available to her when she had the opportunity to be in charge of their medical care and their medical treatment. She threw out everything that came before, gave her very uninformed opinion to the doctor, and went with that. Took her a while to even get one of the children, not both, but one of the children for an exam. Plans for the children, her plans are very vague. As you'll recall, Your Honor, there was a lot of saying that she will figure it out. She will figure it out. Well, if they come home, then I'll change my schedule. Well, if they need this, then I will figure it out. If I'm short on money, I will figure it out. There's no actual plans. There's nobody outside of CPS that she said she could rely on, that she said she could go to, other than the sober living facility that asked her to leave for failure to follow the rules. Stability of both parties' homes. Yes, Ms. Bushman has been in her residence for 6 months. It took her a long time, and in fact, losing the children in order for her to get up and get the motivation to get that place secured. And that was with the heavy assistance of her caseworker. There is no demonstration that she is going to be able to maintain that if somebody is not there holding her hand through all of that. And we can't be there forever. That's not what these cases are for. Acts or omissions of parenting. We've had 3 hearings, and to each testimony that there's no reason. We've got lots for her failure to meet these needs. You know, we've got professionals that said they have taught her how to not use drugs. They have professionals that say they have taught her to, or parenting classes, you know, that she's learned to do that. But we don't have anybody that's testifying that she's actually putting these things into place. It's actually the opposite. And that leaves us with no excuses for the acts of omission. Ms. Bushman clearly loves her children, and the children seem to enjoy their tie with her. But I am absolutely certain that at this time, if the children could tell me what they want, it would be to remain where they are, where they have consistently maintained a safe, loving relationship that has met all of their needs, while hopefully continuing a relationship with Ms. Bushman in the future. I don't think that they would necessarily want her gone from their lives, but I don't think that she can care for them. And I don't think that there is a possible legal solution to this, where we have the Fords and Ms. Bushman and Mr. Martin co-parenting in any kind of manageable way. For those reasons, I am not supporting a transitional monitored return, a regular monitored return, or a full immediate return to the children. I appreciate the position that Ms. Bushman has been in, and I do appreciate the changes that she has been able to make during this case. However, she has not demonstrated that these are long-term, ongoing changes with full understanding of the needs of twin toddlers and getting older children. I do not believe that she can meet their needs in the future, now, or even 6 months from now with a little bit of monitoring. So for those reasons, I'm not supporting any kind of monitored return. I think that the testimony and the evidence have clearly established that both parents place the children in danger to actions both before and after their birth. I think that Mr. Martin has failed to complete his service plan, failed to provide any kind of service. He is here today solely riding the coattails of Ms. Bushman, who has admittedly done some work.
Thank you, Ms. Harris. Ms. Price, as promised, I'll give you a few minutes for rebuttal.
Thank you, Your Honor. Your Honor, I will also go ahead and briefly address the Hawley factors. I think that, but I first want to remind the court that Chapter 161.001 of the Family Code says that the court may order termination of the parent-child relationship with the findings, not that it has to, not that it must, not that it's required. And so when we then look at the Hawley factors, because again, I think the addiction is established. So what is in the children's best interest? And ultimately, these are children who are nonverbal. And the testimony was that they are very bonded to Miss Bushman, and also that they are bonded to Mr. and Mrs. Ford, which we would expect and want from foster parents. And so I think that at best, that comes in evenly, but it's not clear and convincing evidence of termination. The emotional and physical needs of the child now and in the future, the children's needs are well established by the evidence in this case. But at the end of the day, the evidence did indicate that Ms. Bushman got them with a provider, got Jameson the swallow study, was in the process of getting them the speech language pathology set up. And so what that comes down to is that we don't like how quickly she did it, or the way that she did it, or that she didn't think to require that the medical professional meet with the other medical professional or get the records. But what's not clear is to what extent she even had the opportunity to go to any of these medical appointments. She is criticized for not doing so, but there was no evidence that she was able to, or that there were orders for her to, or that there was cooperation with her to do so, or that there was advocacy for her to be able to do so. And so I believe that at the end of the day, that the emotional and physical needs of the child now and in the future do not raise to the level of termination being in their best interest. The emotional and physical danger to the children now and in the future, I think, also is addressed by what the department is asking for, which is a transition for the court to be able to monitor this and ensure that they are not in emotional and physical danger during this monitored return, which, again, does not raise the level that termination is in their best interest. The parental abilities of the individual seeking custody, of course, we are going to expect and see that the Ford's parenting abilities are superior, because that's what we expect from foster parents. In fact, it's required for them to be licensed in the first place. But the evidence that's been brought before this court about Ms. Bushman's disbelief of the severity of the children's needs, her belief that there was maybe some exaggeration of those needs to make her look bad, that is exactly what we would expect from a parent who is under the kind of microscope that Ms. Bushman has been under, that we would expect that she would feel those kinds of things. But despite her feelings, she still went and took them to obtain the treatment and the services that they need. And so I think that leans in favor of her retaining her parental rights. She has absolutely taken advantage of all of the services and programs available to her. The evidence to that point has been overwhelming from all of even the treatment providers who ultimately had her leave the facility, said that they continue to have interactions with her. Her plans, I don't believe, were vague. She knew which daycare she had them in the past. She knows which doctor she had them with in the past. And she indicated that she would have the time to be able to get those services set up again. She has the housing. She has the furniture. She has her own place set up to be able to begin immediately meeting their needs. And for the stability factor, Your Honor, yes, she has been in this place for 6 months. And for somebody who has had the history of addiction that she has had, this time she made the changes that were necessary. This time was different than the other times. And the evidence of that was clear and overwhelming throughout the case. And I don't believe that factor supports termination. And as far as any excuse for the acts or omissions, Ms. Bushman admitted to her use during this case. She admitted to the rough beginnings that she had and the history that she's had. And I don't think she was seeking to minimize or excuse those. I think that she instead was trying to own up to that part of her history, which we cannot erase. But Your Honor, at this point, I believe that the evidence does not meet the clear and convincing requirement that it's in the children's best rights to terminate parental rights in this case. And we do ask that the court issue or order the transitional monitor to return. Thank you.
Thank you, Ms. Price. We will be in recess until 3 o'clock. I'll come back at 3 o'clock and give my ruling. See you at 3.
A little longer than a few minutes later.
Dismissing Ms. Harris. There she is. Ms. Hyman, are you ready?
Yes, Your Honor.
We're going to go back on the record. This is cause number 23-01-28129-CV in the interest of Jasmine Bushman et al. Thank you for your patience. I'm going to give my ruling, and during the ruling, the only person that should be talking is me. And I'll set aside time after my ruling to make any clarifying orders that are necessary. This is a difficult case. I'm glad it came to me, because as difficult as it is and as much pressure as it puts upon a judge, I know that I'm sitting here making a ruling after considering all of the evidence and operating under the established law, the case law, and the evidence that you all have presented here, which I want to commend all the attorneys for their excellent advocacy for their clients in this case. As most of you here know, the best interest of the children is the primary consideration of the court. There is, as Ms. Pearsall pointed out, legislation and public policy geared towards reunification with biological family. And this court, as several of you have been a part of, has returned many children home. And I acknowledge Ms. Bushman's efforts throughout the course of this case to maintain her sobriety and to better her life. And I commend you on that and want you to continue to do that, because it can only get better from there as far as your sobriety goes. There were several arguments made that alluded to maybe other cases or other situations. And I want to make sure that this court has made this decision based on the fact that the facts and circumstances of this particular case are not like any other case where children are either returned home or not returned home. It's a unique and complicated case, as which most of these cases often are when we get to this point in procedure. When we get to the point of final trial, things are complicated. The Holly factors were discussed, and that includes a look at the needs of the children, not only now, but also in the future. And then the emotional and physical danger of the parents now and in the future. And then also the abilities of the parents we have here and the parents who are seeking custody. The court's standard here is unequivocally not what's in the best interest of any parents or any person seeking custody. It is about the best interest of children. This case is already in an extension, and there's been a lot of discussion about that throughout the course of this trial. The court finds that returning the children to Ms. Bushman would not be in the best interest of the children, as it would cause a significant impairment to the physical health or emotional development of the children. Court finds that the non-parent interveners have shown, by a preponderance of the evidence, several factors which I'm going to outline here in my ruling. Court finds that these children need permanency, and although the court has the option to order a monitored return, as has been requested, court declines to do so because the court finds that the mother already had one failed monitored return. And although Ms. Price made a very good argument to the perils of parenting, court finds that Ms. Bushman is still not reacting to the children's medical needs appropriately after over a year of help and support. Court finds that a speech therapist testified as to the needs of the children now, going into great detail in her testimony that the children need a swallow study every 6 months and still need thickener. Court is not convinced, nor does the court find Ms. Bushman or Mr. Martin credible that Ms. Bushman will appropriately address those issues in the future without constant supervision. That's not possible. Ms. Pearsall argued that if a parent gets it together, they should get their kids back. Court finds through Ms. Bushman's pattern of behavior, including during these proceedings, that although Ms. Bushman might have logistically gotten some things together, she has not convinced this court that she can provide for the needs of the children now and in the future. Court finds that she has completed services on her family plan of service, but she has not met the goal of the service plan of being able to meet the needs of the children. Court finds that she was not able to stop vaping, and she was smoking for a certain point of time. Court finds that she was not able to maintain a safe and stable household while the children were in her care. They were removed from her care, not once, but twice during the life of this case. And the court finds that even long after inpatient drug treatment, she still had a positive drug result for methamphetamine. Court finds that this case was initiated due to methamphetamine use and neglect. Court finds that Ms. Bushman has not only minimized the health issues throughout the case, but her very behaviors and reactions, including her own testimony in this trial, was that she believed everyone else was making a bigger deal about the medical concerns than was necessary. She reacted to Ms. Swallow's closing argument in a manner that I could only infer to this minute was that the children's health issues to her are not as severe as all of the professionals and the experts testified. This is of great concern to the court for the future safety and needs of the children now, again, and in the future. That's a best interest factor that I cannot ignore. No length of stability in an apartment or a job can overcome such a startling fact. The court observed Ms. Bushman nodding her head when it was mentioned that the breathing treatments were causing the children to have problems, which is further evidence to the court that she does not take the diagnoses of the children by medical professionals and therapists seriously. That is of great concern to the court regarding her ability to parent in the future when there's no supervision on her care or the physical needs of the children. The court finds that Ms. Bushman endangered the children, and then throughout the course of this case has shown through her specific acts and omissions that she continued smoking and vaping during the case despite the knowledge of the children having chronic lung disease. And despite that knowledge, she has minimized their medical diagnoses and conditions. She did not seek intensive and thorough medical intervention during her monitored return. She went to one doctor's visit. She made the decision after that one doctor's visit to take the children who, it's been testified to and is not in dispute, are silent aspirators, off their thickener based on that one physician's examination. Despite her being made well aware throughout the course of this case that they needed speech therapy and swallow studies to make sure they were getting adequate treatment for their condition. Court finds that the children are bonded to the foster parents and have a safe, stable, appropriate placement that meets their needs. The court finds that the court-appointed special advocate has the same concerns after making approximately 10 visits and observing the mother with the children. The court-appointed special advocate testified that there's a pattern in the mother's behavior of failing to put the children's needs before her own. Court finds that the court-appointed special advocate had concerns about Ms. Bushman's long-term ability to care for the children, and she pointed out that sobriety doesn't always equal a safe and stable home. The court finds that the disparity of income between the mother, Ms. Bushman, or the father, Mr. Martin, and the foster parents has absolutely no bearing on this decision. In that regard, the court has only considered the ability to provide the children with a safe, stable, drug-free home that can meet their needs based on the evidence presented. The court finds by clear and convincing evidence that the department and Belong made reasonable efforts to return the children to the parent before the commencement of a trial on the merits. And despite those reasonable efforts, a continuing danger remains in the home that prevents the return of the child to the parent. That continuing danger be what I just laid out in my previous findings. Court specifically finds we just lost somebody. Who do we leave? Who do we lose? Was it Mr. Martin?
Yes.
All right, well, we'll see if we can get him back, but I'm going to keep going. Court specifically finds that those reasonable efforts include returning the children to the parent and attempting to avoid a removal by utilizing a safety plan and supervision resources, developing a family plan of service narrowly tailored to address the concerns that brought the children into the care of department and Belong, attempting a monitored return to the mother in this case that failed based on the specific acts and omissions of the mother, and requesting the court to extend the case to allow the mother an additional monitored return, which the court has denied as stated in the court's findings and rulings in this final order. The court finds that the interveners have proved by clear and convincing evidence that both parents, Tracy Bushman and Corey Martin, have, pursuant to Chapter 161.001 B1, have knowingly placed or knowingly allowed the children to remain in conditions or surroundings which endangered the physical or emotional well-being of the children, engaged in conduct or knowingly placed the children with persons who engaged in conduct which endangered the physical or emotional well-being of the children, failed to support the children in accordance with the parent's ability during a period of 1 year ending within 6 months of the date of the filing of the petition. For the mother, for both parents, been the cause of the child being addicted to alcohol or a controlled substance other than a controlled substance legally obtained by prescription. That's for both parents. And then for the father, the court will additionally find that Mr. Martin constructively abandoned the child who has been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 6 months, and the department has made reasonable efforts to return the child to the parent. The parent is not regularly visited or maintained significant contact with the child, and the parent has demonstrated an inability to provide the child with a safe environment. And Mr. Martin also failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of the child. Additionally, for the mother, court finds that the interveners have proved by clear and convincing evidence pursuant to Chapter 161.001B that under P, she used a controlled substance as defined by Chapter 481 Health and Safety Code in a manner that endangered the health or the safety of the child and after completion of a court-ordered substance abuse treatment program, continue to abuse a controlled substance. For the purposes of the record, the statute provisions for the father are 161.001 B1D, E, F, N, and O. And for the mother, there are 161.001 B1D, E, F, P, and R. Court further finds that these terminations of parents' parental rights pursuant to these provisions of the statute proved by clear and convincing evidence are in the best interest of the children, and it's in the best interest to terminate the parental rights of both parents. The attorneys for the parents, Ms. Savage and Ms. Pearsall, are dismissed. Court finds that they have satisfactorily completed their duties. The attorney ad litem, Ms. Harris, and CASA advocate are maintained in their respective appointments or relationships to the court. We'll have a permanency review after final order October the 8th, 2024 at 10 a.m. October 8th, 2024 at 10 a.m. Court finds that placement of the children with the foster parents is safe, appropriate, meeting their needs, and in their best interest to continue. I can provide my docket notes if you need them to draft the order. At this time, are there any clarifying questions?
Judge, I would just request that the children not be moved absent court order.
So ordered.
Thank you.
Judge, is it the court's desire that the department prepare the final order?
I think since Ms. Swallow's clients were seeking termination, they should prepare the termination order, but I want it circulated. I want everybody to sign it. I want everybody to make sure it's right. Anything else? Ms. Swallow, have I failed to address anything?
No, Judge, thank you.
All right, this has been a long trial. It's been multiple settings. I want to thank you all for your time and your service. And the only thing I can say to Ms. Bushman is that these decisions are never easy for me. They're extremely difficult. These are the days that I dread, but this is the job that I'm paid to do. And so I'm doing it. And I wish you good luck. And thank you all for your time and your service. I'll see you on October the 8th. Nothing further. All parties are excused. Thank you.
Thank you, Honor.